I made the decision to retire because my loyalty, my first loyalty, comes to the people of North Carolina to whom I took an oath to do the best job I could, and to the court system because I believe in the rule of law is important, and keeping the courts functioning and not being impaired is important, and more important than the party that I carry as my party label. They were just assuming that I would go along with their plan, which was to reduce the size of the Court of Appeals. Well, they should have looked at my resume and seen that I was a former federal prosecutor and a colonel in the Marines. We don't back down from doing the right thing merely because of a party label. They didn't ask me as to whether I'd go along with that. I'd done everything I could possibly do to get them to not do that, given them alternative legislation, had the Chief Justices write letters to every member of the legislature. Our own colleagues had tried to go to the Judiciary Committee and give them actual statistics showing that we're pretty busy as a court and we don't need to be impaired in the way they were going to do it. And in my career, not only on the bench, but living here in North Carolina, this is the first time I've seen a legislative body deliberately impair the court system. I've never seen that happen before. By doing this the way I did, I ensured that the Court of Appeals stayed at 15 judges at least for the next couple of years. It's a real small step that I took. It only affects one seat on the Court of Appeals, but I know that that means 120 cases a year will be heard in the right time frame. And so I think that when people hear my story, they're proud of me for what I've done, and it's going to turn them against these proposed changes. At least that would be my hope.